The Honorable Judges of the United States Court of Appeals in and for the 7th Judicial Circuit, hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention as the court is now sitting. God save the United States and this honorable court.
Good morning, ladies and gentlemen. Our first case for argument this morning is Huggins against ABK Tracking. Mr. Telfine.
Good morning, Your Honors, and may it please the Court. My name is Phil Telfian, and along with my co-counsel, Lily Millwit, I represent the plaintiffs, William Huggins and Hobart Miller. This court should reverse the district court's ruling below for 3 reasons. First, Rooker-Feldman does not apply to issues that are facially unmentioned in a state court order because unstated issues are necessarily consistent with any federal relief. Second, Younger cannot apply to third-party conduct that does not interfere with any state court proceeding. And third, the defendant's alternative arguments are improper without a cross-appeal because they would leave the plaintiffs in a worse position than we are under the district court's ruling. I'm prepared to elaborate on each topic, but I defer first and foremost to this court's questions. The rule we propose under the Rooker-Feldman doctrine directs district courts to look only at the text of state court orders. And
Mr. Telfine, before we get into that question, I want to make sure that I understand the current status of the 2 plaintiffs. Is either one of them now in prison?
neither is in prison, no, Your Honor.
Is there a prosecution pending against either one of them?
Not as it relates to the current charges, no, Your Honor.
Forget the current charges. Is a prosecution pending against either one of them? We're trying to figure out what the prospective effect of your request is.
I see, Your Honor. Well, Mr. Huggins is still serving supervision under ABK as part of his probationary sentence, so he still has prospective effect. With regard to Mr. Miller, we believe the inherently transitory doctrine should apply to his case. His charges were dismissed.
Is he promising to violate the law again in the future?
We don't think that's a requirement.
Yes, it is. That's the holding of Weinstein against Bradford.
For the inherently transitory doctrine?
Yes.
Then we respectfully ask this court to revisit that question, because under that rule it would be
Decision of the Supreme Court of the United States.
And
we are not at liberty to upset their decisions.
Understood, Your Honor, but under that rule it would be almost impossible for any pretrial litigation to be heard in federal court.
Well, that may be so. And that's what happened in Los Angeles against Lyons, as you may be aware. All right, so we have one of the plaintiffs is now still on supervision, so presumably there could be another revocation. Has any request for revocation of that supervision been made?
I'm glad Your Honor asked the question, because our case does not hinge on revocation at all. Our case is tied to this.
Just answer my question, please, and then you can tell me why I shouldn't have asked it.
We're not aware of a pending request for revocation, no.
Okay. All right, now proceed.
Turning to the Rooker-Feldman question, we believe the text of the state court order should control. As we've tried repeatedly in our briefing to direct the court's attention, the state court orders are available in the separate appendix at pages 168 and 214 for Mr. Huggins and Mr. Miller, respectively. Neither document mentions any of the fees that are being challenged in this case. Both state court orders do mention certain fees. For example, Mr. Huggins was ordered to a $60 per month pretrial services fee. I want to make very clear that's very different than the fees, that ABK's fees that were challenging in this court. Both individuals were subject to a $10 ID replacement fee, also completely different than the fees being challenged in this case.
And I think it'd be, I guess, Gilbank, the most recent decision by this court in regards to Rooker-Feldman somewhat answered that question regarding the fourth step. I would be interested if we sidestepped Rooker-Feldman and looked more at standing for each individual defendant. And so maybe starting with ABK, maybe ending with ABK might be the most helpful. But if we start with the judge, and I know there was a finding below that the judge was operating as a state official. And so why would we have standing?
Well, we think we have standing against all three defendants. The first point I did want to make, though, is that we think these alternative arguments, because they weren't reached by the district court, would leave us in a worse position than we started with. To the extent it's a jurisdictional question, of course, this court can and should address it. But the arguments that the defendants are making, our reading is mostly non-jurisdictional. With regard to the jurisdiction over Mr. Keeley, who is no longer a judge, we have sued him as the architect of what we believe is an unconstitutional conflict of interest. Without turning to the merits, he was, at least as the facts allege, the official who created the conflict. And so standing to answer Your Honor's question would be under Ex parte Young. Whether he was a state or county official, Ex parte Young, even as a state official, would give us right to seek prospective relief, either declaratory or injunctive.
You just said that he's no longer a judge. What prospective relief would be available?
We think under the Ex parte Young doctrine, the official, because we sued him in his official capacity, his replacement in office.
If you sue him in an official capacity, you can't use Ex parte Young. If you sue him in an official capacity, you are suing the state. And under Will against Michigan Department of State Police, state officials are not persons for purposes of 1983.
We would argue that the individual sued in their official capacity is still a proper defendant before this court. And that's how we've sued.
You argue that. How do you avoid Will against Michigan Department of State Police?
Only under the theory that he's being sued under Ex parte Young. That's our basis for jurisdiction over the defendant.
The holding of Will is that states and state officials are not persons for purposes of 1983. It doesn't depend on the plaintiff's legal theory.
Understood,
It's a
Your Honor.
statement about who is a person.
Understood, but to the extent that Mr. Keeley is viewed as a state official, we think Ex parte Young would apply. If he's viewed as a county official,
Do you have any authority for the proposition that we can just ignore Will whenever somebody says, intones Ex parte Young?
no, Your Honor.
No,
But
there is no such authority.
we also
You
believe.
might want to stick with your claims against the other defendants.
Thank you, Your Honor. We also believe that Mr. Keeley, in his role as designing the ABK program, was acting as a county policymaker. He wasn't acting on behalf of the
You
state.
didn't raise that issue until your reply brief, so it's been abandoned. The district court said he acted as a state official. Now, you could challenge that in your opening brief, but I didn't see any challenge.
Your Honor, we believe the district court improperly reached that issue because once the district
Did you
court.
raise this in your opening brief?
No, Your Honor, we did not.
No, you did not. It's been abandoned.
Why don't we move to ABK tracking? And why do we have standing in regards to ABK tracking? Rooker-Feldman, in your argument, doesn't apply.
Would Your Honor clarify, you're saying if Rooker-Feldman does not apply? As long as Rooker-Feldman does not apply, there's complete jurisdiction over ABK.
Right.
And as long as either plaintiff remains having standing, which at least Mr. Huggins does, there's jurisdiction over the parties and ABK. Rooker-Feldman is the only jurisdictional barrier that we're aware of that could possibly be argued against ABK. The district court did turn to younger abstention as well. I will note in passing, once the district court found that it had no jurisdiction under Rooker-Feldman, we think it's improper for it to have addressed the state or county issue or the younger issue.
I don't see how there would be a younger problem if there is no current prosecution pending, because that's the premise of younger.
We agree, Your Honor.
But that's why I began by making sure that nobody is now in prison and there is no prosecution pending saying that somebody should go to prison for not paying ABK's fees.
Thank you, Your Honor. We think that's one important reason why Younger would not apply in this case. Even if there were pending prosecutions in this case, none of the relief we're seeking, we think the Gilbank rule is equally important in the Younger context. This court should look at the relief. None of the relief we're seeking could possibly interfere with, even if there were ongoing state proceedings, there's no possible interference. What we think is important on Younger is to note that this would be—
I don't understand that at all. I mean, you don't need that argument. But when I was thinking about this case and your claim that ABK's fees are effectively disguised taxes, which with money being returned to the state, the question that entered my mind is, would you make an equal argument against a criminal fine?
We would not make an equal argument.
Money raised from the defendant and put in the state coffers at the behest of state judges, right? And if you don't argue against the fine, I don't understand what's wrong with a disguised fine.
Respectfully, Your Honor, we think that question turns to the merits of our case, which is—
But you should deal with it.
I'm happy, Your Honor, to deal with it. We think under the state court jurisprudence, many of the cases before the court, like Burnett and Coleman, have held that fees not explicitly ordered in a state court are not valid. So in state court, if it was not part of the court order, it's not valid.
There is some problem under state law. You need to be in state court. You can't be in federal court urging a state law problem. That's one of the holdings not only of Will, but of Pennhurst. Federal court lacks authority to render relief against a state based on an error of state law.
Let me rephrase my question as a federal issue. Under the due process clause, when a state court judge, the federal due process clause, when a state court judge orders a fine, we assume we don't just assume the individual has received the process that is due to them. They've had a public hearing, they've had an appointment of counsel, they've had argument, and so forth.
Is there any problem with a hearing when when there's a proposal to revoke release on account of not paying ABK's fees?
On the merits of this case,
I'm not asking about the merits. I'm asking about whether there is a hearing problem.
Yes.
If the judge opposes a fine and the defendant doesn't pay, there can be a hearing if somebody says he should be sent back to prison. I assume there's a hearing if somebody says they haven't paid ABK, please send him to prison. At least there's an opportunity for a hearing.
It's an assumption Your Honor is entitled to make.
But isn't that what happened here? There was a petition to revoke filed because of an inability to pay the fee? So
there's two steps here. In this record, there is, to Judge Easterbrook's first part of the question, a judge never ordered the fees, so it automatically departs from the hypothetical you're raising.
Yeah, you have to deal with the hypothetical as it's phrased,
yes,
rather than as you wish I had phrased it.
I just want to clarify, in this case, a judge never ordered the fees. In the hypothetical that Judge Easterbrook says, where a judge orders the fees, which did not happen in this case, it would be a radically different due process argument.
I wish you would deal with the question as asked.
As asked, our arguments would not apply to that case. In other words, we would not be able to succeed in that case. Critical in this case.
I don't understand why not.
Because
the argument you're making in your brief is that there's some constitutional problem, conflict of interest, because a state judge is ordering the payment of money that may end up in the state coffers. That's why I asked about fines. It's an explicit order by the judge for money that ends up in state coffers. And if you don't think that's a constitutional problem, why does it become a constitutional problem if it's disguised in a way by being run through a third party?
Thank you, Your Honor. Regarding count one, Your Honor is exactly correct. We would have the same argument. I thought I digged myself down the wrong road of the due process clause. The due process, the hearing requirement would have been met in Your Honor's hypothetical, but there could still be a conflict of interest.
Why is there a difference in ordering an explicit fine and ordering a payment of fees, part of which ends up in the state treasury? In either case, the judge is ordering the payment of money.
To retract, Your Honor, on the conflict of interest claim, there would be no difference whether the judge ordered it. Regarding counts two and
so your argument is essentially attacking the constitutionality of fines and forfeitures, both of which extract money and it ends up in public coffers.
In this specific case,
I'm not asking about this specific case. I am asking about the general constitutionality of orders to pay money that end up in public coffers.
In the general case, what this court should look to is the individuals who set up the arrangement and the individuals benefiting from it. In this case, the conflict is very strong because the individuals ordering the fees in the hypothetical that Your Honor is giving are the same individuals benefiting from it. In other words, the judge is able to satisfy his own coffers.
I have one more question that I should ask you before your time expires, which is, how would damages be available since neither of the plaintiffs is now in prison or on his way there? How would damages be available consistent with the principle of Heck against Humphrey?
We don't think Heck against Humphrey can apply to cases either that are pretrial, which our case involves.
This is not pretrial. The reason your clients are objecting is because they may be sent back to prison for not paying ABK's fees, and at least one that's happened to. The state court order returning Huggins to prison has not been reviewed or set aside. That's why I'm asking a Heck question.
We don't see the Heck inquiry as being relevant to a pretrial order because state courts are powerless to reverse pretrial orders once those orders expire. Given that neither
I am talking not about pretrial orders, but about an order revoking the terms of release. That's what this litigation has been about. It's been your contention that release is revoked for failing to pay ABK's fees. Fine. That has to have happened to at least one of your clients, or there's never been a case or controversy. So I'm assuming it's happened. And then, if that order has not been set aside, how are damages consistent with Heck?
To the extent this court reads our cases hinging on revocation, we seek leave to amend because we believe standing is proper at the moment any plaintiff had to pay fees to ABK. Even if there were no revocation, the loss of money we think creates damages under Article 3. There was a revocation.
You're not dealing with Heck. The Supreme Court assumed in Heck that damages would be available if the state judgment had been set aside. I'm asking how damages are available before the judgment returning Huggins to prison has been set aside.
So we have two brief responses on Heck. Under the state court process, because revocation is a pretrial order, there is no way to reverse it. So we don't think Heck makes sense to apply.
So you think, let me be clear, maybe this is weird. You think in Indiana, somebody can be sent to prison, the keys be thrown away and have no appellate opportunities at all?
We think a pretrial revocation.
I am not asking about nomenclature. I am asking whether you are submitting, we will have to research this, that you are submitting that in Indiana, if you don't pay ABK's fees and you're sent back to prison, no appellate relief is available as a matter of law ever.
I'm ignorant on that specific question, but the revocations in this case are unreviewable.
I'm not asking about this case for the very last time.
I see.
I asked a general question of law about Indiana law.
So there are two pieces of Indiana law that would be relevant here, whether the revocation is reviewable, which we think is not always the case, and
Not
whether
always the case.
exactly.
What state law do you think we should look at?
I think the court should look at a revocation that does not involve the individuals being sent back to
I
jail.
asked you a concrete question. What state law should I look at?
On that question, we would file a brief update on the state law after the argument. But regarding the fees, which are
We think a further briefing is necessary. We will let you know. Thank you, counsel.
Thank you, Your Honors.
Mr. Beeman.
May it please the court, judge, counsel, all in attendance, thanks for having us at the law school today. I want to address, I'm going to take 13 minutes to address my client who's ABK tracking, and I'm arguing on behalf of Judge Kiley here, state of Indiana as well, if there's any questions with regard to that.
Is he a judge?
Judge Kiley he is a judge, but he's no longer a judge, but he can't be He was at all times a state official. It's very clear under Indiana law, a judge in Indiana is a state official, even in the
If-
concept that they're acting as a probation officer.
Yeah, I didn't pursue this with your adversary, but if he was sued in his official capacity and he's no longer a judge, his successor is substituted automatically under federal law. So who is his successor?
That's a great question. I don't know the answer to that, but you're suing, if you're suing the person in the official capacity, you're suing them in the context that they're the state of Indiana. And then there's judicial immunities and 11th Amendment sovereign immunity issues.
No, you do not reach the 11th Amendment unless there is some statute authorizing a suit, right? I've gone through this with your adversary under Will against Michigan Department of State Police. The states and their official suit in their official capacity are not persons and therefore can't be sued in the first place. The Supreme Court has summarily reversed courts of appeals that have announced sovereign immunity rulings in such cases, pointing out that you can't have a sovereign immunity defense unless there's a claim. And I can't see the claim. Maybe I'm missing something.
No, I agree with you. I don't see the claim either. I want to address first, back to your first point you brought up, Judge
Why is there
Easterbrook,
no claim?
against Judge Kiley, because he was not acting as an official of the county at the time. So he was not a policymaker. I want to address the mootness issue and the status of both of these individuals. Both Huggins and Miller have no pending criminal cases. Full stop. Huggins,
Supervised release, Mr. Huggins?
no. So Huggins was on supervised. He was petition to revoke issues happened. He was removed from EHD, placed on the drug adult probation services, and then he was actually, because of the petition to revoke, he submitted some false evidence in the underlying case, the subject of the order here. He was revoked and had to serve what they call therapeutic work release.
I assume he wasn't revoked. His release was revoked.
Sorry, he wasn't revoked. Yeah, his release was revoked more appropriately.
So I'm now even more confused. What is his status? Is he now on supervision or not?
No, as of in the underlying case, which is 82D03 2104 F6 1925, he was completed work release, time served April 3rd, 2024. He got
He's
charged.
not under any kind of supervision now?
He got charged with the subsequent case and served that already too, and it actually just expired. He was time served as of October 2nd, 2024. And that
October
case
2nd?
is 82D03-2303 F6 1450. That was also a Vanderburgh County case.
All right.
It actually arose out of the submission of the false evidence in the underlying case.
And he
Same
completed
proceeding
supervised
number.
release on the first case in April of 2024?
April of 2024, correct.
At the time of the filing, he was still under supervised release conditions?
At the time of the filing of the complaint in this case? Yes, correct.
All right.
I want to address the first thing that council brought up was the facial and whether fees were included in the order, or how do we view that fees included in the order? I agree with Judge Brookman in this case that I think that's largely illusory in this case, because I don't think you can separate the order that obligates that payment of the fee from the condition that they serve the sentence on AVK tracking or serve
Some
pretrial.
sort of
AVK tracking.
inextricably intertwined argument?
I hate to use that
has
language.
hit the dust. It's gone. It's just bye-bye.
Yeah, I know. Well, I'm not saying, I don't want to use the word inextricably intertwined,
Good
but
job.
But if you're
but the
making-
fee,
if you're making the same argument by another name, it's just as gone as if you use that name.
well, I think that they provided supplemental authority in the Taylor case, for instance, right? And in a subsequent case, and I'm missing the name of that one off the top of my head right now. But basically, they're trying to argue in those cases that it actually has to be in the text of the order. So the fee would need to be in the text of the order. Now, I've read Gilbank numerous times.
It's pretty simple.
It's a good
Gilbank is
read.
Pretty simple.
Right? Judge Kirsch wrote obviously the majority opinion on that. And I read your majority opinion not
It
to.
is an opinion of the court.
It's an opinion of the
These
entire
are not
court.
ad hominem arguments, don't work.
Yeah, sorry, Judge. It's a majority opinion of the court. It's binding precedent on us. I read Gilbank not to be in accordance with that. Because what is cited in Gilbank are cases where Rooker-Feldman would still apply where you're seeking return of damages from that state court judgment. Okay? If damages were included in that judgment, nothing says it has to be actually in the text of that judgment.
So what I'm hearing from you is the fourth step of Gilbank. The state court judgments were not the cause of the plaintiff's injury.
I'm saying impliedly they were, even though facially it does not specify the fee in there. Now, my colleague brings up a good point. I think the plaintiffs have a great argument as to whether the fee should have been included. They absolutely should have been included. The Vanderburgh County probation orders are deficient in my mind with respect to, if you read Burnett, Coleman, a number of those cases, there's been numerous challenges to probationary orders where they do not specify the fees that you're going to pay, even for drug testing. A lot of those came out of Marion County, and it was an effort by the Marion County Public Defender's Office to address that concern. I think that's deficient, but that's a state court law violation. Burnett and Coleman are based on violation of the Indiana state law, not some constitutional basis. Could you make a constitutional argument about that? Sure, you could. But the reason why the fees are in there is a problem, a state law problem. Theoretically, they actually should be specified in there. So I also think that's another way to distinguish between whether it actually needs to be in the text or not.
I'm lost again. Maybe they should have been there, but they aren't. So in what way would a federal judgment that the fees shouldn't be more than $20 be inconsistent with the actual state judgment as opposed to the wished for state judgment?
Well, I read Gilbank to...
I didn't ask you a question about Gilbank. I asked you a question about in what way would the federal relief be inconsistent with a judgment that doesn't specify the amount of fees? Then we can talk about Gilbank.
It doesn't specifically specify the amount of the fees.
Yes.
But what it does say is you are going to drug abuse probation services, or you're
Yes.
going to adult
Fine.
abuse probation services, and you have to comply with that order or the designated official's order, who is the third party. And it specifically sets forth that. Again, I agree.
Suppose ABK says, I want you to run a marathon. I want you to run 26 miles, or until you drop dead, whichever is first. The state judgment doesn't say that, but ABK says that. And you've been committed to the tender mercies of ABK. You come to federal court and say, I don't want them to kill me by forcing me to run a marathon. Would there be any inconsistency between a federal order saying you don't have to run a marathon and the terms of the state judgment?
Yes, because they were all understood based on plaintiff's own allegations and pleadings and statements. They understood that they had to pay for that service.
No.
But the run,
Look,
They're not
I
paying
hope-
for the run.
Why are you not listening to my question? I asked you if ABK just decides you got to run a marathon or we're going to ask your probation to be revoked. What would be the inconsistency between a federal court order saying you don't have to run a marathon and the actual state judgment?
Nothing.
There would be
nothing.
no inconsistency
Nothing
at all, right?
Agreed.
And so there wouldn't be a Rooker-Feldman problem.
Agreed.
Now, if there's no inconsistency there, where this is all made up by ABK, why is there any inconsistency in the actual situation where the fees are made up by ABK rather than specified by the court?
Because the fees are being paid for that what's specifically set forth in the order, which is that drug abuse probation services or the adult probation services.
But it
It's
tells
not like
you-
the order says nothing about the service that they
But it
have to
says nothing
comply
about
with.
fees using Judge Easterbrook's,
I agree. I agree. It says nothing about fees, and it should say something about fees,
but it doesn't.
and it doesn't.
And so because it doesn't state anything about fees, why is the state court judgment then the source of the plaintiff's injuries?
Well, if you disagree with I think it's impliedly attuned, then I think we lose on Rooker-Feldman, period, based on Gilbank. I still think you can
I
affirm.
hate to introduce yet another line of cases, but I do not for the life of me understand what Rooker-Feldman could have to do with or ever has had to do with judicial orders that could send people back to prison. Right? The premise of the Rooker-Feldman doctrine is a statute that gives the Supreme Court of the United States exclusive jurisdiction in civil cases. The Supreme Court has never had exclusive jurisdiction in criminal cases. And in fact, 28 U.S.C. 2241 and 2254 allow federal courts to review the judgments of state courts in criminal cases. So how could Rooker-Feldman ever apply in a criminal case?
Well, I think what we're talking about are the fees, not
I'm
being
asking what
subject
you're
to.
talking about. I asked a general question of law. Given the intellectual basis of the Rooker-Feldman doctrine and the two statutes providing for review in criminal cases, how can the Rooker-Feldman doctrine ever apply in a criminal case?
That's a good question, and I don't think I fully understood it before
It's a
Gilbank.
question that we have to answer because Rooker-Feldman is jurisdictional. And we
Agreed.
therefore have to answer this question whether you have argued it or not.
Yeah, no, I agree. And in Gilbank, you were dissented regarding the
Gilbank was a
Heck.
civil case.
I agree, but the Heck versus Humphrey discussion we had earlier today with my co-counsel obviously is, I think, subject to something that we'll have to explore as to whether it would actually bar this case in general in the first place. We also raised res judicata on the underlying case, and that wasn't on basis of the decision.
2241 and 2254 don't respect res judicata of state decisions either. Okay, thank you, Mr. Beeman.
Thank you, Judge.
Mr. Loberman.
Good morning, Your Honors, and may it please the court. My name is Bernard Loberman, and I represent, Vanderburgh County. And I know there's been some discussion on Judge Kiley's alleged relationship with Vanderburgh County thus far, but
Are those two judges that implemented the orders in this case, are they county officials?
no, they are not, Your Honor. What we made clear in our briefing and based on this court's decision in Woods is that under Indiana law, Indiana trial court judges are state actors for the actions that they take within that role. Here, what the appellants have suggested is that Judge Kiley was a county policymaker and administrator. It's paragraph 19 of their complaint, and I'm quoting, "is a county policymaker and administrator as both head of the probation department and the architect of the ABK policy." That is exactly the premise that Judge Brookman analyzed in the briefing on the motions to dismiss, where he found that based on those allegations, Judge Kiley could only be a state actor. He's not employed by Vanderburgh County. He doesn't set policy for Vanderburgh County. Any decisions that he takes with respect to probation administration and things of that nature, based on the Indiana Supreme Court's precedent in the Lake County case, though probation activities are also, the language they used was they are an arm of the trial court. They are not functionally distinguished from the trial court itself with respect to being state agents. So,
If they're not county officials, why do we have standing?
we don't have standing as to Vanderburgh County because any claim against the county is not redressable, first and foremost. Any order that the trial court could have issued, whether it be on monetary relief or an injunctive relief, Vandenberg County would have no ability to redress. And as the court pointed out earlier in the earlier colloquy, appellants did not pursue this issue in their opening brief before this court, and it wasn't until their reply that they suggested an alternative theory that the agency relationship was not with Judge Kiley, but with ABK directly. And setting aside, for the sake of argument, the waiver on that issue, I see my time has expired, but
Thank you, counsel.
thank you, Your Honor.
Mr. Telfian, I'll give you a minute for rebuttal.
Just two brief points on rebuttal, Your Honors, and again, may it please the court. Count 2 in this case is a deprivation of property. We'd want to emphasize it before the court. Does not turn on revocation. It seeks damages. The damages do not turn on the pending status of either plaintiff. We think the damages claims are still live. Both plaintiffs are putative class representatives for a putative class in this case, of course.
Class certified?
This case was dismissed on a motion to dismiss, so we have not yet even had the opportunity to move for
They're not
certification.
class representatives.
No, Your Honor, but we think the prospective claims could be held under a theory of a putative class, as many of this court's precedents have held. The count 2 in this case, not turning on revocation, is critical because it highlights the injury that we're seeking damages for, which was the moment ABK demanded fees, absent any court orders, absent any judicial or due process authorization. We think that's an injury that on the merits should be heard in the district court. Thank you, Your Honors.
Mr. Telfian, before you go, I asked you whether either of the two plaintiffs is still on supervision.
Yes.
And you said Huggins is still on supervision. Mr. Beeman said expressly that his supervision has ended, both on the judgment that initially led to this case and on the subsequent one. Is that correct?
I haven't spoken to Mr. Huggins since October 2nd, which was the date Mr. Beeman gave.
This off a docket sheet. You don't need to speak with him.
Absolutely, Your Honor.
I would like counsel to confer on this subject after the argument and to file a letter with the court with the correct information about whether Huggins is still on any form of supervision.
We will, Your Honor.
I would appreciate that. The whole court will appreciate that. Thank you.
Thank you, Your Honor.
The case is taken under advisement. Our second case for argument today is Satanic Temple Incorporated against Repeating. Mr. McNaughton.
Good morning, Your Honors. James McNaughton for the appellants. When TST filed this lawsuit, it had a very specific,
Excuse me, when what?
I'm sorry,
When what?
TST,
If you would use real words, that would help.
when the appellants filed this lawsuit, they had a very specific and concrete intention to provide abortifacients to its members nationwide. As I stand before the court here today, it has implemented that plan. And it stands ready.
Counsel, let me tell you what the big problem here is, at least for me. I understand you to be challenging a particular law in Indiana, commonly known as SB 1. If a federal court were to hold that law unconstitutional, would that provide any relief at all to the Satanic Temple?
Yes.
And what relief would that be?
It would be able to provide abortifacients to its members in Indiana.
No, they would not. There are other statutes on the books in Indiana requiring these drugs to be approved personally by a physician after at least one in-person visit. And your client, so far as I can tell, doesn't have physicians on its staff, doesn't propose to have in-person visits, and therefore would still be as barred from offering its potential services as it is with SB1 on the books.
Okay.
I'm asking a question, in other words, about redressability.
SB1 is the name of the Senate bill. The statute that we are challenging is the section in the Indiana Code that makes it a criminal activity to violate the terms of Section 1 of the regulations of abortion, which,
I understand that,
But-
but there
okay.
are other statutes, right? The question I'm asking is, if the statute you want enjoined were enjoined,
yes,
wouldn't that leave your client in exactly the same position it now is?
no,
So tell me why.
okay, because what we're asked, the relief that we're asking for is to be relieved from the threat of criminal prosecution.
For violating a particular statute,
That's correct.
not
let
for
me-
violating all
Let
Indiana
me,
statutes.
yes, let me finish my argument, which is that redressability does not have to mean we have the absolute right to go in and provide it. It's that we have the right to go in and provide it without going to jail. These other
But
statutes.
you would go to jail by offering these drugs without the prescription of a physician following multiple meetings, right? That's an offense in Indiana. You're not asking for an injunction of that
Yeah,
statute,
the
right? That's my problem.
the appellant has the use of a physician licensed in Indiana to prescribe these drugs after a telecommunications
That's the
consultation.
problem here in
It's a
Indiana.
problem. It's
Yeah,
illegal in Indiana.
I understand that. Here's what I'm trying to tell you.
But if you can't engage in the conduct, how can there be a threat or an injury?
Because Section 7A makes engaging in telecommunications, telehealth, a crime. Okay? We're asking to have that sanction for that activity stricken.
I didn't
as
see any
unconst-
mention of that in your complaint or in your brief. What am I missing?
The scope of the definition of SB1, okay? SB1 amended Section 7 of that provision of the code and made it applicable to Section 1 in its entirety. Section 1 in its entirety includes not only the prohibition with respect to timing, it also includes the prohibitions with respect to having a hospital, having a doctor, having in-person visits. So what we are asking for is to have all of those provisions.
There's
And I
no
don't see
clue
that.
about that in your brief. Absolutely no clue.
Well, then I must, I must not have spelled it out clearly enough, because I thought I made it very clear that if you go, that one of the difficulties that I've had with this case is thinking about it or analyzing, quote, SB1, which is not itself a statute. It is a bill that amends a statute. And if you follow the amendment,
Because I'm perceiving this to be a different argument than what was presented in the brief, it might be helpful to direct us to where this argument is contained. You said you didn't spell it out, so let's see and direct us to where you want us to go. Because redressability is something that we have to answer.
I understand.
All right.
Okay, if you look at footnote 8 on page 11 of my brief, okay? It says SB1 refers to the Senate bill. I've attached a copy in my exhibit, okay? It amended Indiana Code Section 1634-2-1 by, among other things, limiting abortion to cases where pregnancy puts the mother's life at risk. Now, SB1 made the level 5 felony provisions of Indiana Code 34-7-7A applicable to Indiana Code Section 1634-2-1 in its entirety. Okay?
I'm still lost. I've read the footnote. I don't see what that has to do to imply, even to imply that you're raising a challenge to statutes quite apart from SB1 that regulate telehealth provisions in
Section
the context of abortion.
1, 1634.
If you hold SB1 unconstitutional, it's undone. Do you think that automatically vacates all Indiana abortion laws?
I'm not asking to invalidate SB1. If you read the complaint, we're asking.
I don't read the complaint. I read appellate briefs. I read district judges' opinions. I read your brief to figure out what the legal argument against the district judge's opinion is. And I continue to express frustration that I don't find in your brief any intelligible challenge to the many state laws regulating telehealth with respect to abortion.
I'm challenging 1634-2-7A. And that is alleged in the complaint. That statute makes the provisions of 34-2-1 in its entirety. Any violation of those provisions.
I don't.
Let me finish. Your Honor, please, let me finish. Section 1 covers all of these, what you are calling.
You're not saying anything relevant. That's my problem.
Section.
I'll let you go on, but you have to understand that unless you can answer the question as I posed it, that you have no hope in this
Okay,
case.
I'm trying. Okay, let's take the physician. Let's take the hospital as an example. Okay, TST does not have a hospital. Okay, it's our allegation that if you provide a medical abortion outside of a hospital under SB1, that's a crime.
Isn't it a crime under other statutes as well?
No,
There's no other
it's not
statutes.
a level 5. It's not a level 5 felony.
We're not asking whether it's a level 5 felony. We're asking whether it is lawful in Indiana. And there are other statutes under which providing telehealth for abortion is not lawful in Indiana. It doesn't make any difference whether it's level 5, level 2.
It does.
It's not lawful in the state of Indiana.
With all due respect, Your Honor, it does. And let me explain why. Okay, because the level 5 felony is a crime. Redressability does not mean that we strike the statute altogether and we have a carte blanche. It means that if we do it, we don't go to jail. If we have to contend with civil sanctions or contend with hearings in front of, say, a medical board, cross that bridge when we get to it. But right now, what we're challenging is the fact that providing abortifacients in a hospital, outside of a hospital, is a crime in the state of Indiana. We don't have a hospital. We're a virtual clinic. We'll never have a hospital. We'll never have a clinic.
But you won't have a doctor to perform an
Yes, we do.
abortion
We
outside of the hospital either.
We have a doctor who can prescribe abortifacients in accordance with the FDA requirements by
That's in
telemedicine.
violation.
Is that in the record?
She came on board after the complaint was filed.
So
It
no,
is-
it's not in the record.
It's not in the record. It's a matter of public record. And I pointed that out in my brief. If you took, it's Dr. JD, if you put Dr. JD's name into the Indiana physicians database, you'll see her correct name. So we have Dr. JD. She can sit at a computer terminal with a Zoom and prescribe abortifacients to Indiana residents.
No, she can't.
Yes,
It's illegal in Indiana to do that.
that's right.
What you may be saying is, I would like the federal court to enter an order that will help us perform illegal things. I think you may find that there are many obstacles to that kind of relief.
I'm not asking the court for a carte blanche to provide illegal things. I'm asking the court for an order declaring that Dr. JD will not go to jail for committing a level 5 felony. That's sufficient redress. That is sufficient redress to
But if
give
you
us standing.
cannot engage in the conduct,
I'm sorry?
if we were to impose what you're asking, there are other Indiana statutes that would still prohibit Dr. JD from engaging in this conduct.
So
That's what
I am told. I have yet to see them.
You've yet to see the.
I have yet to see them. I
That
have,
particular Indiana law has already been sustained by the Seventh Circuit and the Supreme Court of the United States. If you haven't yet to see it, that suggests a certain deficiency of legal research.
which specific law are we talking about?
It is not my job to answer your
Okay.
questions.
I haven't seen it. I haven't seen any other
That's
statutes.
obvious.
Can I ask you a question about
Sure.
sovereign immunity? Is there a sovereign immunity problem here? It seems to me that what you're seeking is injunctive and declaratory relief under Indiana law, under the Indiana Religious Freedom Restoration Act.
No, we're not pressing that claim. We're pressing the claim under Section 1983 for violation of constitutional rights.
Okay.
And again, with all due respect, Your Honor, it is illegal, you're right, it is illegal for Dr. JD to prescribe abortifacients by telemedicine to an Indiana resident. That's a violation of Section 1, and that makes it a crime. But I have yet to see any other statute, all right, that inhibits that activity in any way, shape, or form. If it exists,
I suggest you read our opinion in Whole Women's Health against Rokita, 13 Fed 4, 595. This is not the time to do it, but you should have done it before filing this case.
well, I reserve what little time I have left. Thank you, Your Honor.
Ms. Lawrence.
May it please the court. Plaintiffs bear the burden of showing that they have standing at every stage of every case. The Satanic Temple has failed to do that here, despite repeated opportunities to do so. They have first failed to show that any individual member of their organization has standing to challenge SB 1. And second, they have not shown that they have standing as an organization, that they will actually be injured, or that any relief offered by this court will relieve that injury. Beginning with the associational standing problem, Summers against Earth Island Institute sets out that when an association brings a
Just drill down, I think it moves quicker. Disability rights, Wisconsin, right? And so what do we do with that case now that we have Summers to kind of direct us?
Yes, Your Honor, I think there are three things that this court can do in dealing with disability rights, Wisconsin, and each of those build on each other. So the first is that Prairie Rivers, a more recent decision of this court, asked whether disability rights statement that you don't have to name a member even survives the Summers decision. The second is to look to both Prairie Rivers and disability rights, because there, in Prairie Rivers, they set aside the issue of whether you needed to name a individual, but they said you had to at least identify them, and that Summers explicitly rejected the type of statistical analysis that the Satanic Temple is trying to do. And even in disability rights Wisconsin, there the court found that it did not have jurisdiction because the disability rights group hadn't said that a single member would be harmed by the law that was at issue. And that's the problem here. Even with the statistical analysis, setting aside from all of the problems with that analysis, which I'm happy to discuss if the court would like to, but even if this court takes that statistical analysis at its word, it only said that there were that number of women who were pregnant in a year. It did not say that those women wanted an abortion. It did not say that they were not able to procure an abortion under Indiana's current laws, nor did it say that any of those women would seek to use the Satanic Temple to effectuate that abortion. So at very minimum, the Satanic Temple must at least identify an individual who has been harmed by this law, who is a member of their organization, and they simply have not. The second way that the Satanic Temple has failed to establish standing is as an organization in and of itself. Now, to begin with, there is
Before we
a,
move there, though, there's a line of cases, in particular focused on the NAACP cases. Those are the ones that were brought up in the briefing. And how do we distinguish those from the facts of this case?
yes, Your Honor, there's two key ways to distinguish the NAACP case and others from the facts of this case in Summers. So the first is that in NAACP, every single member of the organization would be harmed by disclosure of their identities. In this case, the Satanic Temple hasn't alleged that every single member of their organization will be harmed. In fact, they've only said that it's statistically likely that 94 members of the organization might be pregnant, not that they would even be harmed in a given year. And the second way to distinguish NAACP is that even within NAACP, there still were named members of that group who were involved in the litigation. The leaders of the organization, here there are no identified or named members of the Satanic Temple before the court today to press those concerns. So here, because the Satanic Temple hasn't alleged that every single member will be injured, they cannot represent the entire organization as a whole in the way that NAACP did in that exception to the Summers rule of naming an individual. Now, as we in standing in their own right, the Satanic Temple does have a sovereign immunity issue. As the district court pointed out in their complaint, count 4 and count 5 were specific to violations of the Indiana Religious Freedom Restoration Act. And if perhaps there were...
Mr. McNaughton says that he has abandoned all state law claims. So on claim under federal law, how would a sovereign immunity issue arise given Will against Michigan Department of State Police, the subject of the last oral argument?
Because, Your Honor, we didn't brief any of those federal issues.
No, you didn't brief any of these things. That's one of the reasons we have oral argument.
Yes.
But as I said in the last argument, the Supreme Court has chastised courts of appeals for gratuitously making constitutional sovereign immunity holdings when the defendant is not a person for purposes of 1983.
Even if that were the case, there's still a redressability and causation issues with the Satanic Temple's argument. Now, as Your Honors have pointed out, there are other independent Indiana laws that would stop the Satanic Temple from operating in Indiana under their telemedicine model. And second, I want to talk a little bit about this idea that they have a doctor that they know of who is registered to practice medicine in Indiana. The state doesn't doubt that that's true, but the question is when the district court looked to see whether they had standing, the Satanic Temple actually, this is in Appendix 265, 264 to 265, they disclaimed having any doctors on staff or the decision to hire any doctors on staff who would be employed in Indiana. For the first time now in this reply brief, they let us know that they know of a doctor who is licensed in Indiana, but even today, the Satanic Temple has not said that they plan to employ that doctor from Indiana. And again, we're not even saying that they have to have employed her. They just simply haven't said that they are going to. Without any concrete allegations of their intention to provide these abortions in Indiana, it is impossible for them to have standing here. I also would like to turn the court's attention to page 33, 34, and 35 of the appellant's brief, because there they specifically disclaimed to this court the intention of performing abortions in Indiana. They said that if they are granted their relief, then other doctors already in Indiana will be able to provide abortions to TST members there, which will allow the Satanic Temple to go on to its other activities. Similarly, this idea that they are not actually going to ever provide abortions in Indiana is the argument that the Satanic Temple has put before this court, and they should be held to that that statement that they made to the court in their opening brief. Unless the court has any further questions, we ask this court to affirm the district court.
Hearing none, thank you very much, counsel. Mr. McNaughton, anything further?
In my remaining 1 minute and 25 seconds, no court has addressed the issue we raise here of whether the individual members of the association have a First Amendment right to remain anonymous. It was not
How would there be a First Amendment right to remain anonymous from the judge?
from the judge.
I can understand an argument for anonymity from the public at large.
Yes,
But the argument you're making is that they don't have to be identified, even to the judge in confidence.
that's correct.
And what's the authority for that?
Oh, there's no requirement under Article 3 that they be identified to anybody. None.
You say that, but I'm asking a concrete question.
Right.
What's the authority for the proposition that people who say we are at risk
Yes,
don't have to be identified even to the judge?
the First Amendment. It is not an absolute right.
You,
It is not an absolute
Look.
right.
I am trying to get you to cite either a statute or a case. I am taking your answer as saying I have neither a statute nor a case.
I do have a case.
Then tell me what it is.
The Buckley case. The Buckley case provides that if you have a First Amendment right, it is not absolute. It is not absolute.
It had nothing to do with not identifying litigants even to a judge. I wish you would answer the question that I asked rather than the question you wish I had
Okay,
asked.
then the answer is there are no cases on this point, one way or the other. There just aren't.
Okay, thank you.
Thank you.
The case is taken under advisement. We'll hear argument now in the case of United States against Rose. Mr. Holler.
Good morning, Your Honors, and may it please the Court, David Holler on behalf of the United States. Title 18 United States Code, Section 922G4 is constitutional as applied to defendant Rose. In concluding to the contrary, we believe that the district court made essentially three errors. First, the court demanded production of a historical American law that looked enough like the contested modern regulation. Rahimi, and we believe also Gay, stand for the proposition that that was incorrect. In addition, the court stated that the defendant was denied the ability to demonstrate his mental fitness for a firearm possession under Indiana law. That too is incorrect. He was not denied reinstatement by a court following completion of a statutory process. It is not even clear that the Noble County Court understood that the defendant was filing.
Let me interject and tell you what my main worry is about your line of argument, which really deals with both of the themes you've just articulated. And that is that you think that the Constitution allows a burden to be put on the potential person buying a firearm. If you look at Rahimi, it seemed to be very important to the Supreme Court in Rahimi that the burden was on the state or the complainant to show current dangerousness. You seem to be saying, well, no, we can shift the burden to somebody who's ever had a civil commitment to show the absence of dangerousness. It's very hard to get that out of Rahimi. Is there some way to get that out of that burden shifting, out of the historical precedents?
Well, Your Honor, I guess what I would state is that if we go back, even back to Heller, as well as to Rahimi.
No. I'm asking about either Rahimi or the historical antecedents of statutes like this.
So the historical antecedents of statutes like this is that there were categories of people who were deemed to be sufficiently dangerous.
Or deemed to be sufficiently dangerous. Yeah, I understand that. Let's assume that a person who has just been acquitted on grounds of insanity, of murder with a dangerous weapon, is in that category. There's no doubt that this statute is constitutional on its face. It's got lots of valid applications. What I'm trying to hone in on is if you have somebody who was in a mental institution 10 years ago and has been released, is it permissible to throw on him the burden of showing lack of dangerousness? Because that's what the Indiana statute does, and by clear and convincing evidence to boot, right? That's where I'm asking you to focus your attention. Are there historical precedents for that?
Well, what we would state, Your Honor, is that the historical precedent is, in the context of mental illness, is that individuals who were deemed dangerously mentally ill would be imprisoned, would be deprived of firearms. And then there was nothing at that point.
Yeah, it's not the problem here. We have somebody who was in a mental institution some time ago, has been out, and says, I'm harmless now. Maybe true or false. But the Indiana process, I'll say this for the last time, requires him to prove it to the satisfaction of state officials by clear and convincing evidence. In other words, it's a form of may-issue scheme. And the Supreme Court in Bruin distinguished may-issue schemes from must-issue schemes. We've got a may-issue scheme in Indiana. How is that lining up with the Supreme Court's precedent? That's what I'm trying to get you to discuss.
Okay, so again, once a person was institutionalized, there were no standards or procedures for them to get out of the institution in the first place. So they could be institutionalized forevermore. There wasn't a specific procedure for them to demonstrate that they were no longer dangerous. They have categorically demonstrated that those people are more dangerous. Congress in 1968 essentially stated, we believe as a category that people who have been mentally institutionalized are dangerous individuals and present a sufficient danger, and therefore those people can be deprived. That is what the procedure is. But I would also point out that the defendant—
I understand that that's the statute, but you're not dealing with my question.
I'm not sure I know how better to deal with that question other than what we have stated.
In what way is Indiana's system of restoring rights for somebody who has been in an institution different from the may-issue permit system at issue in Bruin?
Both procedures require the
person who wants to have a firearm to show to the satisfaction of state officials that he's a good guy and entitled and should be entitled. That's why the system in Bruin was held unconstitutional.
Well, that particular scheme required the defendant to show a special need to possess a firearm, not to show that they were not
The burden
dangerous.
was on the applicant. Right? The fundamental holding of Bruin is that may-issue systems are invalid, but must-issue systems, subject to conditions, are valid. And as I say, Indiana appears to have a may-issue system for anybody who's ever been in a mental institution. Am I missing something?
I think that the difference between Bruin and this case is that I don't believe that Bruin holds that if a system says you may issue the firearm only if there is a showing that you are not dangerous is unconstitutional. It doesn't speak to that question.
It's crystal clear in Bruin that that's unconstitutional. Crystal clear. You can't read the decision any other way. All may-issue systems are out after Bruin.
The defendant has to make some showing that they are not dangerously mentally ill.
But
They
that's
have
the
to make that
question.
showing.
That's the
Why
problem.
you're shifting the burden after Bruin and Rahimi in particular, where it's clear from the Supreme Court that people have a right to bear arms under the Second Amendment. And the question, going back to the original question Justice Easterbrook posed, was where in the historical precedent of the country have we required, in particular those that have been deemed mentally ill at some point, to require them to show that they're no longer perceived to be a danger to be able to now acquire firearms? This may, shifting that burden to, in this case, Mr. Rose, versus the government having to demonstrate not being entitled after that, let's say, after that involuntary commitment is over, not being entitled to go out and grab a gun?
The historical precedent is that when people were deemed dangerously mentally ill, they were confined in prisons or in mental hospitals. And then if at some point the state believed that they were no longer dangerous, then at that point they were released and could have a firearm. There is no evidence that there were the same sort of due process standards that now exist back in the 1790s. There's no evidence that the state can say, we're not convinced, we're not going to release you. Those due process burdens came in place in the 1970s in O'Connor versus Ellison and those decisions.
Yeah, but I don't think you're even grasping the problem. The historical precedents are along the lines of, if you are dangerously mentally ill, you can't have a firearm, right? The question then, based on the historical antecedents, is Rose dangerously mentally ill now, right? What we know is he was once in a mental institution. We know that he is not shown by clear and convincing evidence that he is not now mentally ill. What do you do about states of uncertainty? The historical record doesn't seem to deal with states of uncertainty or with who bears the burden of showing dangerousness or lack of dangerousness. In Rahimi, there was a burden that had already been discharged of showing that Rahimi was dangerous right now. That was the foundation of the Supreme Court's holding in Rahimi. But what's the basis for thinking that Rose is dangerous now, today?
So the basis for thinking that Rose is dangerous now, today, is the data that was established, which shows that people, even after release from mental institutions, present a danger of violence and present a much greater danger of violence than ordinary society. And I, respectfully, Judge Easterbrook, I do not read Bruin, which applies to people who have never demonstrated such a danger, to suggest that those same kinds of regimes and some kinds of additional requirements may not be placed on people who have not already demonstrated that they present a danger.
The most recent question on the table is, what is the reason for believing that Rose is dangerous today? Right? We knew the answer to that question in Rahimi. What is the reason for giving an affirmative answer to that question with respect to Rose now?
So there is sparse evidence in the record because this was decided on a complaint and a motion to dismiss.
Why isn't the answer just his commitment to the mental institution at some point in the past?
Well, that is essentially what we can rely on at this point, is the commitment to the mental institution. And then to state, whether this was
that enough?
Well, I guess my point would be, let's assume for the sake of argument that Indiana had a shall issue regime, and that when Mr. Rose filed his application with the Noble County Court misunderstood it. He still has the burden to go through the state procedures and challenge those state procedures as unconstitutional.
Why?
Because the statute there still is, even in the Bruin context, Your Honors, the court still said that shall issue regimes are permissible. You still have to go and state, I would like a firearm. There's nothing wrong with that minimal burden. So that sort of procedure at minimum would not be unconstitutional in light of any Supreme Court precedent.
We're looking at the finding of fact that the judge made in that initial order for Mr. Rose, that there was a factual finding that Mr. Rose at the time was a danger. And for that reason, you're involuntarily committed.
He was involuntarily committed in 2009 based on a finding of dangerousness. Mm-hmm. So then the question becomes, at what point and how do we determine that he is no longer a danger? That's the question. And I don't know that there are no historical principles that said that there were any minimal standards to determine that position. That simply is not present in the record. People were placed into mental institutions, and many of them remain there long after they should have, because there were no standards for their release. This is why the mental institutions were emptied in the 1970s after the Supreme Court and other courts started reviewing these issues more closely. So in the 1790s, once a determination had been made that Mr. Rose was mentally ill and dangerous, there's no reason to think that he ever would have been released. Perhaps he would have been, perhaps he would not have been. But that, I don't think based on that historical record that one can conclude today that he is not mentally ill. The way to conclude that is the way the statute provides, and he did not follow that procedure. I would like to reserve the remainder of my time for rebuttal.
Certainly, counsel. Mr. Pennington.
Your Honor, good morning. May it please the court. Chad Pennington on behalf of Mr. Rose. To go directly to your question, Judge Easterbrook, there is no historical antecedent that functions in the same way as 922G4 did in this particular case. There is no history and tradition from the requisite period, which is the time of the founding, that establishes that a person once
Let's
released.
assume that's true. Does that decide the case in your favor? The United States says, this is page 29 of its brief, that when Rose bought his guns, he was receiving Social Security disability payments based on current mental illness, not mental illness 10 years ago, but mental illness at the time he bought his guns. Why isn't that all the prosecution needs?
Your Honor, I think it's not enough for the prosecution if we look at Rahimi specifically. If he's receiving state benefits of some kind based on some sort of mental defect or mental impairment, whatever it may be, however one wants to be characterized, that doesn't establish the requisite level of dangerousness. And what Rahimi's specifically alluding to is dangerousness and an active finding of that.
The prosecutor cites the receipt of Social Security benefits. Now, I could imagine a response along the lines of, Rose applied for benefits on the ground of being unemployable because people wrongly thought he was dangerous, but he's not. But you didn't respond along those lines. In fact, you completely ignored the issue. Well, now's your chance to respond. If we go and look at the Social Security record, is that what we'll find?
Your Honor, I don't know exactly what we'll find if we go to the Social Security record.
It's an oral argument in the Court of Appeals. It's a little late to say, I don't know what we'll find about an issue raised by the prosecutor as a reason for putting Mr. Rose in prison for a very long time.
Your Honor, I think our response would be that the case law under Rahimi is that the deprivation is permissible if there's an active finding of dangerousness and a Social Security disability as it relates to.
For all we know, Rose told the Social Security Administration that he was uncontrollably violent, and that's why he can't be employed. And the Social Security Administration bought it. The terms of disability benefits require you to notify SSA just as soon as anything changes. And I take it from the prosecutor's reference that Rose has never told the Social Security Administration that he is no longer disabled, mentally disabled. You think that's a problem if that's what he told the Social Security Administration? You think there's a problem preventing him from having guns?
Your Honor, to address the question specifically, I think in the absence of a record about what exactly he told the Social Security.
Then that's a problem. How do we hold the statute unconstitutional in the absence of a record on an absolutely critical question, which is whether Rose is dangerous today?
Your Honor, I think the absence of the record on the as-applied challenge, that's going to redound in Mr. Rose's favor.
No,
we also have
the person bearing the burden, the legal burden on a constitutional challenge to a statute is the challenger, not the United States.
Your Honor, under the Second
You
Amendment.
have been challenged by Mr. Holler with the fact of the Social Security disability benefits, and you have chosen to ignore that challenge. It's not something that you can then say to the Court of Appeals, well, we ignored it, so we win. No, it doesn't work that way.
Your Honor, I wouldn't say we're ignoring it. I'm saying it's not a controlling fact.
You did ignore it. You were asked about that. It's relied on by the United States, and your brief doesn't mention the topic.
Your Honor, because I don't think that the reliance is permissible. And that's the fundamental flaw with saying we're going to rely on some.
We need, my best reading of Rahimi, maybe it's not yours, maybe it's not Mr. Holler's, is that a showing of current dangerousness is important, right? The prosecutor says one reason to believe that Rose is dangerous today is his ongoing receipt of disability benefits based on a mental impairment. And Rose says nothing in response. Well, if you leave a critical argument like that unanswered, what's the court supposed to do?
Your Honor, I think that there's other portions of the record that can be cited to, which is specifically, as Judge Kirsch was alluding to, is he was released from the mental facility, and the government makes a big...
But does that remove the finding of dangerousness under involuntary temporary commitment? But neither party engaged with the statute that says the limit is 90 days. So irrespective of the 90 days after that ran, you were to be released. And so are you suggesting because he was released, there was a finding that he was no longer dangerous?
Your Honor, what I'm saying is if he was released, there was either a finding that he was no longer dangerous, or the Indiana officials chose not to extend the commitment. Either way...
But you're the one raising the as-applied challenge, so where do I go to get the answer to that question?
Your Honor, I would say specifically when it comes to the nature of the challenge, the question is not Mr. Rose's exercise of the right. It's he has the right. It's a pre-existing right. The question is the government's deprivation of that right, and whether the deprivation is rooted in history and tradition. And specifically when we're saying here in this...
We have a history and tradition of restricting categorically firearms from those that are deemed to be dangerous. And we have a finding in the record that Mr. Rose poses a danger.
Your Honor, I would say that the case law is, when you look at history and tradition pursuant to Rahimi, it's based on that particular statute, edition 922G8, it's what's critical is the credible active finding of dangerousness. That was existing in the Texas Protective Order. Here he was committed in 2009. It was extended into early 2010. And then what we know from the record with absolute certainty is the commitment ended. And that's much different than Rahimi, where the actual disability was still in place. And so Congress's authority to strip the person...
But you're trying to attach the 90 days running to undoing the finding of dangerousness. And so I'm needing support in the record to get me there. I understand your argument, but now I'm asking for the support for the argument.
Your Honor, I would say the support for the argument that he's no longer dangerous, as understood at Rahimi, is he is...
No, going to the record. That's why Judge Easterbrook is bringing up the disability filings. That's why he's bringing up the record.
Your Honor, correct. I think as the state of the record is currently, what we have is that he was released, and that's what we would point to. Whether the release is based on a finding of whether he was or wasn't...
So we don't know anything about why he was released?
I think, Your Honor, we know that he was released.
We know that he was released.
And we know...
But we don't know why he was released.
We know why he was committed, and we know that the commitment ended, and the commitment was related to...
We don't know why. I'm just... If you think that the record shows why, please tell me.
That's all I need.
Because it's important.
Mm-hmm.
Do you think the record shows why he was released?
Your Honor, I think that the record shows, it doesn't show specifically why he was released.
So the answer is no. We've now got two unsettled problems. We don't know why he was released. We don't know why he is still receiving disability benefits based on a finding of some mental problem. How do we get a constitutional decision out of that as applied when there are still important things we don't know?
Your Honor, I think that what we're doing here is we're trying to decide whether to affirm the district court's decision or not. And the district court made a decision that the government hadn't proffered sufficient history and tradition. And I think that when you look at the record that was presented before the district court...
The history and tradition, I think, is pretty well established that people who are currently dangerous for mental reasons can't possess firearms. There's a history of that. If that's what G4 is saying, fine. But how do you hold that statute unconstitutional as applied to Rose when we don't know whether Rose is currently dangerous?
Your Honor, I think that I don't think the record supports that he is currently dangerous.
It doesn't say one way or the other so far as I can tell.
I think in the absence of saying that it doesn't show that he's currently dangerous, I don't think the government can establish that he's currently dangerous.
It might have to establish that in order to get a conviction. But how do we hold the statute unconstitutional as applied to Rose when we don't know whether Rose is currently dangerous?
Your Honor,
if we knew he's currently dangerous, then it's valid to apply it to him. If we think he's currently not dangerous, then it's not proper to apply it to him. But if we don't know the answer, how do we get a constitutional decision? That's my problem.
Certainly, Your Honor. I think that if we don't know the answer specifically, what we do is on a motion to dismiss is we look at the record that's been presented, and that's through the complaint and that's through the indictment. We know that he was committed for roughly a 90-day period in 2009 and was extended once. So roughly 120 days of commitment. That was in 2009. That was in 2010. He subsequently assumed employment. He's also receiving disability benefits. But we don't.
You're not addressing my question, which is how, if the validity of this statute as applied to Rose turns on whether he is currently dangerous, how can we tell whether the statute is valid as applied to Rose when we don't know whether he is currently dangerous?
I think, Your Honor, there's enough in the record to make the inference that he is no longer dangerous. This happened, the commitment, almost 15 years ago at this point. It's entirely distinguishable from Rahimi, where the person was under an active disability. There was an active finding of current dangerousness.
He is actively receiving Social Security disability benefits based on his own representation that he has an ongoing mental illness. You want us to ignore that. You've got your head in the sand about that. But it's there. It's not going away.
We're not asking you to bury your head in the sand. We're asking you to look at the record that was presented.
No, you didn't ask us to look at the record. You simply ignored the issue.
Your Honor, we're trying to connect the issue as you present the question to Rahimi. And what we're talking about in Rahimi is whether there's the active finding of dangerousness. And if there is, then the government can deprive the Second Amendment right. We don't have the same active finding of dangerousness here. To the extent we had one, as it relates.
Involuntary, that's what the statute, G4 says, involuntary commitment. And involuntary commitment in Indiana as applied to Mr. Rose, in order for that to happen, there must be a finding of dangerousness. We have that here.
That's correct, Your Honor.
We're away from Rahimi now, and we're trying to, as applied to Mr. Rose, if there's still today, is there still a reason to believe that Mr. Rose is in the category of dangerous people?
No, Your Honor, I don't think that there is a reason to believe that he's in the category of those persons. The government cited in its brief prior conviction in 2013. That's now been expunged, and that's over 10 years ago at this point. Since he's been released, there's no criminal conduct in place. There's the receipt of benefits, but there's nothing evincing the level of dangerousness that was talked about in Rahimi, where there was an active finding of dangerousness.
How can you say that when we know nothing about the Social Security benefits? If Rose himself represented to the administration that I am dangerous, and that's why I'm unemployable, and he's under a statutory duty to tell them immediately if anything changes, we can't ignore that.
Your Honor, I think that there's nothing in the record about what he communicated.
There's nothing in the record about it. The prosecutor says he's receiving benefits, and the defense chooses to ignore the subject. The person who has the records is your client.
Your Honor, we're at the motion to dismiss phase, and so the record is the complaint, the record is in the indictment, and that's what the judge ruled upon. And in those specific documents where the government carries the burden to deprive him of his Second Amendment rights, there's nothing in the complaint establishing his active level of dangerousness. And that's the record that the court relied upon in granting the motion to dismiss. Given the state of the record that was presented, I think the court was competent here to say the record was sufficient. He's not an active dangerousness. And I think what the court was specifically saying is he's not laboring under an active mental illness. Just because he's saying there could be some problem to get Social Security benefits, I'm struggling, I'm not well, that's a far cry from necessary mental illness. He does have the prior adjudication, certainly. But his receipt of benefits, I think it's entirely a red herring. That doesn't establish that he's currently suffering from a mental illness or that he would be committable.
It certainly establishes that he is suffering today from a mental illness because he has a statutory obligation to tell the Social Security Administration immediately if anything has changed. Failure to do that is both a civil wrong and a felony. And your client has never told the Social Security Administration that he has recovered.
I don't think
that's the problem. I don't think you're seeing the problem.
Your Honor, I think we're seeing the problem. I think I'm trying my best to explain it to you, but I think that I see the issue. I think what is critical here is the record that was presented to the court through the complaint, through the indictment. That doesn't establish that he's under an active level of dangerousness or there's been an active finding of dangerousness. And with the evidence presented, the district court was competent to make the ruling that it did. And for those reasons, we would ask that this court affirm the district court's finding that 922G4 is unconstitutional as applied to the defendant. Thank you.
Thank you, Mr. Pennington. Anything further, Mr. Haller?
Very briefly, Your Honor. First, on the factual points. Every fact in this record is either in the criminal complaint, which is attached at appendix page 12, or it is in docket entry 9, which is the discussion of the mental health issue. And I'm not going to read that word for word, but it reports that he was diagnosed with some pretty significant mental issues in 2008. And it reports, quote, the defendant currently receives Social Security disability benefits and advised he received said benefits due to his prior mental health diagnosis. Under that prior mental health diagnosis, in 2009 and 2010, he was institutionalized as dangerous. At least at the motion to dismiss stage, there is enough in this record to conclude that this indictment should not have been dismissed. Respectfully, Your Honors, we believe that the Supreme Court's opinion in Rahimi and Justice Gorsuch's concurrence in particular suggest that the Supreme Court has not decided definitively the question of, first of all, whether dangerousness is required, and second of all, whether the government is required to give a temporal limitation to dangerousness or to review that. We believe that is an open question. The court can certainly read the tea leaves in whatever way it wishes to. The government reads it differently. But I believe at minimum the court should concede that the Supreme Court has not definitively stated that. I'm happy to answer any other questions from the court. Otherwise, I'd like to be respectful of your time, and I thank you for that. We would ask that the judgment of the district court be reversed and that the case be remanded for further proceedings. Thank you.
Thank you, Mr. Haller. The case is taken under advisement, and the court will take a brief recess before calling the fourth case.
Good job, Chad.
Yeah.
This honorable court is now in session. Please be seated and come to order.
Good morning, ladies and gentlemen. We're ready to hear argument now in the case of United States against Gibbs. Mr. Roy.
Thank you, Judge. Good morning. May it please the court, opposing counsel. My name is Michael Roy on behalf of defendant appellant Edward Gibbs. Our position is the district court plainly erred with two of the conditions of supervised release, but from the outset, we recognize, or at least we think that maybe the biggest barriers are the procedural ones. So I'd like to focus first on whether there was a waiver under Flores, unless this court has anything specific it would like me to jump to.
That'd be a good place to start.
Okay. So obviously, I recognize there's not too many plain error conditions of supervised release cases these days since Flores. However, Flores did not change the basic rule or the basic distinction between waiver and forfeiture. The rule is still forfeiture is an oversight. Waiver requires some sort of intentional relinquishment. And that's why our position is the fifth factor of Flores, the requirement that there needs to be something in the record to show an intentional or strategic decision is the most important.
Well, here we have Judge Young asking the question, do you desire me to go over the supervised release conditions?
That's correct. And that would satisfy one of the other factors of Flores, and we agreed, factors 1 through 4.
The intentionality question.
I would disagree that it shows intentionality on its own. I think that's closer to the quick response to a rote colloquy. I think looking at the transcript as a whole, it's not even clear to me that the trial attorney understood that he could challenge the conditions of supervised release. He said that this is a limited hearing, we're just here to pick a number based on the new guidelines range.
Would have received the pre-sentence report that outlined those supervised release conditions as well as the justifications for each one of those supervised release conditions. So is it the contention now that he would not have understood that there was an opportunity to object to the PSR?
Yes, that would be our position. And I think it's looking at him saying, right, we think it's a limited hearing that we're doing. Also, the fact that he didn't familiarize himself enough with the record to even realize that it had been a downward variance at the previous sentencing. I mean, this was 3 years since the previous sentencing. He said, oh, you gave bottom of guidelines last time, give bottom again for the same reasons.
Why does your problem not start with the previous sentencing?
Our position is the previous sentencing is just not part of it. I mean, for several reasons. First, it's a complete resentencing. In Mobley and several other cases, this court has emphasized that usually supervised release conditions, prison term, they're a package deal. So you vacate one, you send both back for remand. So it's a blank slate as far as we're concerned, except for things that would be affected by law of the case or scope of the mandate. Like they wouldn't be able to relitigate the drug quantity, but other parts were still on the table. If he had committed new violations in prison, or if he had pled guilty to a different crime within the two sentencings, the government certainly could have brought that in.
But does your argument with respect to the sentencing, with respect to the conditions, is that tied to the length of incarceration?
I think
In other words, if there was an enhancement, right? If you didn't raise a 2-level gun enhancement at the original sentencing, you appealed something other than the 2-level gun enhancement, you couldn't then raise it at the resentencing. Right, so it wasn't raised at the first sentencing, it wasn't raised on appeal,
Sure.
It goes back for resentencing, you can't then raise the gun enhancement.
Well, I think supervised release is fundamentally different than aspects of the guideline
Why?
calculation, mainly because it's a moving target. That's why there is the ability to move to modify conditions of supervised release. What would have been appropriate in 2020 isn't necessarily appropriate in 2023.
So doesn't that go the other way, though? If there's the opportunity to revise conditions of supervised release, why should they be like the judge's sentence, term of imprisonment of a certain number of months?
I believe you're alluding to maybe prong 4 of the plain error relief, or?
No, I'm alluding to waiver. Why, if you don't raise the condition of supervised release in the first sentencing, okay? Here, in the first sentencing, there were conditions of supervised release that were discussed.
Sure.
Right? So we could find that this condition was waived with respect to the first sentencing.
I think if on the first appeal, if our office had raised the supervised release conditions,
But
no
it-
doubt they would have been waived on that appeal.
Right,
Yes.
but it hadn't.
Right.
And so then it goes back.
Well, I would say we couldn't have on the first appeal, actually.
Right, because it wasn't raised in the
Exactly.
district court, right? So why do you get the opportunity to do it in the second sentencing if you didn't do it in the first?
Because that is the rule from Mobley and from other cases, that once you vacate the prison sentence, or vice versa, if you vacate a condition, you open up both for reconsideration, because you want to see what the judge's intent is as a whole for the complete sentence. I mean, this rule usually comes up in the opposite context, where a condition was vacated on appeal, and there's a question of whether the judge would have imposed more prison time and put in the condition together.
I wonder why your client cares about this, right? That we're having this waiver versus forfeiture argument about a condition that is the equivalent of a Bronx cheer. It has absolutely no content. It says you must tell unspecified people about unidentified things, right? It has no content, and so it can't be violated. And so who cares, right? Why are we here having this debate about something that cannot conceivably affect your client?
Well, I would disagree that it can't be violated. I think that the vagueness of it leaves a lot of discretion to the probation officer.
No, the probation officer has discretion no matter what you do. But the probation officer has to present a case for revocation to the judge. And the judge will pick this up and say, this is content-free, go away. Right? How does it harm your client?
I don't know that it's necessarily content-free. I mean, it's telling him he has to, if his probation officer directs him, notify people of something. And he
Notify people about the cast list in The Wizard of Oz, right? The probation officer says that, and the defendant never notifies them about the Wizard of Oz and moves to revoke, nothing's going to happen.
And I mean, I agree that maybe, predicting down the line the actual revocation hearing, but if there was a condition now that said he would be required to tell people about the cast of cats or something, we would challenge that too on appeal, because it creates that uncertainty. And it's not just about what's going to happen at the later revocation hearing. He's also entitled to know what he is and is not allowed to do, or is not required to do.
Let's sidestep. If we accept that this was not waived, but potentially forfeited, all right, what about the colloquy with Judge Young, Mr. Gibbs, and his counsel suggest, or looking at these two conditions, would attack the fairness or integrity of the proceeding?
Sure. And as we mentioned in the briefs, this court has been a bit inconsistent in how it's discussed prongs 3 and 4 when it comes to.
You're being kind to us.
Thank you, Judge. However, I think that prong 4 is exactly the explanation maybe for inconsistency, in that unlike most appellate rules, prong 4 is like a discretionary rule for an appellate court. And if it comes down to the discretion of this court, obviously we're going to ask this court to exercise its discretion. But I think there's a good argument too. And really the issue comes to whether a motion under 3583 is going to be an appropriate substitute or not. And I think there's several problems with that. First and foremost, he won't have counsel if he files a motion to modify. Just because I filed this appeal, he now has a guideline to work off of, but he wouldn't normally. And it's not really more efficient for this court to direct everything that way, because then you get more pro se motions, more pro se appeals. Without counsel, you don't have the filter of removing the frivolous challenges from the supervision conditions. And also there's the possibility of then having multiple appeals, where if the first appeal and Anders brief needs to be filed, it doesn't really necessarily.
Can I take you to another question? One of your complaints has to do with a condition that deals with psychoactive substances.
Sure.
In your view, is coffee in that status?
Our view is yes.
Chocolate?
Yes.
I'll be asking this of the prosecutor as well. It's
yes.
hard to believe. I mean, chocolate is certainly psychoactive. It's hard to believe the district judge meant to prevent Mr. Gibbs from ever having chocolate. Well, we'll see.
I mean, and that's exactly our position. We recognize, though, it has to not just be vague, but also plain. And so we mostly are relying on, we recognize the mood altering cases, which are slightly different. Colson's the only case.
Well, chocolate and caffeine are both in that category too.
Exactly.
So actually is dinner. If you don't have dinner, you tend to get in a foul mood.
I absolutely agree, Judge. And I position primarily this too, that the inclusion of glue signals to the probation officer that you're not just looking for street drugs, designer drugs. You're rummaging through the pantry, you're rummaging underneath the kitchen sink to find household items that maybe also qualify. I see my time is up. Thank you.
Thank you, Mr. Roy. Mr. Clark.
Colin Clark on behalf of the United States. Thank you to the law school for letting us come here today. This court should decide this case on the issue of waiver and find the claims waived. I think the surest, simplest reason to do that is that Jonathan Chance, the defendant's lawyer, characterized the second sentencing hearing as a limited one, and he was laser focused on getting a lower prison sentence. And if he had spent time nitpicking the supervised...
Let me tell you why I wonder whether any of this matters. It's a different reason from my question to Mr. Roy. The statute says that a judge may change the conditions of supervised release at any time. So presumably, Mr. Gibbs could file such a motion today or in 2 years. Would you be arguing in response to that motion that he has waived any opportunity to make it?
No.
Okay, so he can get this reviewed. The only question is whether it's now or after some further procedure. And since that's the question on the table, why not now?
Why not now? Because it's not the regular process. A lot of these, let's go back to...
Direct appeal is part of the regular process, right? What I asked of Mr. Roy was essentially, why not later? Who cares? I'm asking you, why not now? We live in this world, this curious world, where you can get reviewed on appeal, and 2 years from now, and 5 years from now, and 10 years from now.
You're about to ask me about chocolate and blueberries.
Oh,
and
I'll get there.
But it goes to this point, we were not able to make a record. We did not have the opportunity to make a record. And I think this is a vagueness challenge. If you look at the Hunt case, where the vagueness challenge.
And actually, I wasn't at the moment thinking about the psychoactive substances. I was thinking more about the notify unspecified people about unnamed things, right? That's not going anywhere. Whether we get rid of it now or in 2 years or in 5 years, does anything turn on that?
I think what turns on that is that by forcing pro se or counsel defendants to file motions in the district court will force them to do that as opposed to.
It doesn't force them to do it. You told me that there would be no waiver if tomorrow morning Mr. Gibbs files a motion saying, please set aside that condition.
That is correct.
And so it doesn't force him to raise anything at sentencing.
Force is the wrong word.
Yeah.
I take that back. But I think that by neglecting the procedural niceties of appellate review creates problems not only in limitations of the record, but it also encourages more claims based on issues that were not raised below. This is a court of review, not of first view. And so encouraging.
The court says that, but we are the Court of Appeals.
You are still generally speaking a court of,
The Supreme Court held as a constitutional matter in a case called Marbury against Madison that it is not a court of first view, but we are.
I'm going to understand that this court is always going to have discretion to decide whatever it decides, what's the third or fourth prong of plain error review or that. And so I can only say that I know how I think the court should have used its discretion, but beyond that, I really have nothing to say.
Is it waived? Is this argument waived?
Yes, it is very much waived. It's super waived. And it's waived because, here's why. It's waived because Chance would not have been able to make the argument he made if he went around and nitpicked these supervised release conditions.
Why not?
Because he characterized, his argument was that lower the sentence, this is a limited hearing, and because it's a limited hearing, let's focus on his good conduct and lower the sentence. If you look at the Hunt case.
I want to go back to the words that you used, that he could not challenge supervised release conditions in this hearing.
That is not our position. So he chose not to.
So you misspoke when you said that he could not.
I must have misspoken. If I did not, if I said that, I misspoke. He chose not to do that because he chose the strategy to make it a limited issue on the amount of prison time.
So this is where we're going to Flores saying that this was an intentional strategy.
Yes. Okay. And I see the difference between strategy and intentionality being strategy is he knew the scope of the triable issues, and intentionality meaning he made a mistake and the argument that he made. But in either case, it would have screwed up the strategy he chose to make these arguments about the supervised release conditions. So whether he understood what the scope of the tribal issues were is irrelevant. And if you look at the Canfield case, affirmative mistakes are not the same as negligent omissions. And to find forfeiture, you must find a negligent omission. There was no negligent omission here because you can't say this is a limited hearing, but let's go line by line on the supervised release conditions. And he did know, for whatever it's worth, he did know about what was triable and what wasn't. As you pointed out, they were all in the PSR. And also, the judge asked him on pages 17 and 18 whether the defense had any objections to the supervised release conditions. If nothing else, that put him on notice that he could make an objection. It would be silly for a court to say.
Can the judge go a little further and also ask the question, have you reviewed these conditions with your lawyer?
Yes, that's on page 17 of the second sentencing hearing transcript.
And the answer to that question was yes.
Yes, they had reviewed it, and they were both asked individually, Chance and Gibbs, whether they had objections, and they both said no. And so they chose not to raise this issue. And the reason why I keep pointing to Hunt is because in Hunt, they made the same, it was the same script. Please give us a lower sentence. And that strategy was used to the exclusion of possible other arguments the defense attorney could have made. A defense attorney can always make 1,500 arguments, but if by watering down your arguments, by inundating the judge with all of these points, you might lose the main goal. And here it appears from the record, the main goal was a low sentence. And he got he got more than what he asked for. And so for those reasons, this court should find it waived. But even if you don't find it waived, and even if you want to deal with plain error, as to the psychoactive substances condition, the law is not settled, or at least it favors the United States.
But isn't there tons of case law that suggests that supervised release conditions are intentionally vague? So that when an offender is released from prison, the district court then has the flexibility to ensure that the supervised release conditions that were put in place at the time of sentencing can now be applicable to the offender who has now been released on those conditions.
For that reason, this court should find that the third and fourth prongs of plain error review are not satisfied because, like you point out, this could be fixed. Well, it can be fixed as soon as the mandate returns to the district court.
How would you fix the psychoactive and dangerous substances condition? I understand it when district judges put in things like illegal substances or psychoactive and illegal substances. But think about chocolate. Chocolate is certainly psychoactive, and it's dangerous if you eat too much. You'll die of heart disease, right? So can this defendant eat chocolate or not?
Yes, chocolate is not covered. And
what makes you sure of that?
For a few reasons. One, the court, I believe it's in Siegel, said that this kind of language would eliminate chocolate. And
indeed, we mentioned coffee in that case too.
Yes, and and forgive my Latin pronunciation, the Noscitur Socius canon of construction, the examples listed in the condition limit the reach of the word psychoactive. And because of those examples, the word psychoactive is not given its plain dictionary definition. It's given the limited definition that would fit those examples, and that's why those examples are there. If they wanted the simple dictionary definition, they would have not put the list of examples. Also, it requires an impairment of physical or mental functioning. Coffee, blueberries, chocolate do not impair physical or mental functionings unless you don't give...
A lot of people are impaired by chocolate when they will read.
The impairment that, looking again at the list of examples, the impairment that it must have meant is akin to driving drunk. Because again, the list of examples give the kind of impairment that we're talking about, and the glue we're talking about is not Elmer's glue, but the solvent glue that one can huff. And I see that I'm out of time. Thank you, Court. Unless there are no further questions? Thank you for your time.
Thank you very much. Thanks to both counsel. The case is taken under advisement. Our fifth case for argument this morning is Harrow against Porter County. Ms. Bradley.
Good afternoon, Your Honors, and may it please the court. My name is Alexa Bradley, and I have the privilege of representing Ms. Raquel Harrow, the appellant in this matter. We are here today seeking reversal of the lower court's grant of summary judgment. This case cuts to the core of what must be demanded to preserve human dignity and decency. The Fourth Amendment commands the existence of reasonable suspicion at the moment that a cold stranger carrying the full weight of...
That's consistent with Florence.
Florence, Your Honor, applied to universal strip searches.
They strip searched and did visual body cavity searches on everybody entering the prison. And the majority of the court says that's fine. And everything that you're saying in your brief sounds like it's been taken out of Justice Breyer's dissent. Justice Breyer is a very smart man. He made good points, but he was in dissent.
Correct, Your Honor. And our case differs from Florence because there was no universal strip search policy here. Each strip search had to be.
Doesn't that make the policy better rather than worse, right? The
Of
jail
course.
says we would like to limit how many of these searches we conduct. We try to cut it down and then get sued on the ground that you didn't cut it down enough when they had a right to search absolutely everybody.
Understand.
It can't be that if you try to be more protective of privacy, you open yourself up to suit.
Right, Your Honor, but in Florence, it was recognized, and in this court's case, in Fonder versus Kankakee County, that Florence did not apply to individuals who could be held apart from the general population. Florence dealt with a universal strip.
I can understand an argument that if somebody is being taken into custody, is going to be held in a solitary cell for 2 hours and let go, that Florence wouldn't apply. But I gather from this record that your client was housed with her friends, that's what the record says, was not held by herself. And so we've got somebody who was put in a larger population. That's the Florence bill.
Correct, Your Honor. She was held in, I think it should be clear that Ms. Harrow and her friends were held outside of the general population.
Right, but she was not held by herself.
Correct.
Right, so do you have some case in the wake of Florence saying that Florence doesn't apply to people who are housed in group settings but short of the general population?
Your Honor, we don't have a case on.
And if you look at the reasoning in Florence, it would be hard to imagine such a holding.
Yeah.
Right? Let me tell you what worries me about your argument, that the jail tried to be more protective of privacy and therefore it's open to suit. It sounds just like the argument that was before the Supreme Court in Virginia against Moore, where Virginia says you can't make custodial arrests under the following circumstances. You have to issue somebody a ticket and let them go. The police nonetheless make a custodial arrest. And the Supreme Court of Virginia says, well, under our policy, you should not have made this custodial arrest because we are more protective of privacy than the Fourth Amendment. And since you made the arrest anyway, you've just violated the Fourth Amendment. The Supreme Court says, no, you can't enforce state law through this back door of state law protects privacy extra, and therefore what the state does becomes the constitutional rule. Right? That's the holding of Virginia against Moore. I'm asking you whether you aren't asking us to do the same thing that the Supreme Court of Virginia did in Virginia against Moore.
I don't believe so, Your Honor. I think what is different about a jail, and especially, well, this particular case, a jail that does not have the type of universal strip search policy. Florence did talk about the discretion that is used and
as a matter of state law, any jail can have a policy more protective of privacy. But the holding of Virginia against Moore is that doesn't make violation of the policy a constitutional violation. The Supreme Court has told us in Florence that the Constitution allows every person coming into a prison to be put in anything other than a one-person cell to be strip searched. And with no reason at all, with no suspicion.
But that, Your Honor, is with the application of a universal policy.
No,
This court has.
You're going back to it all depended on state law. And that's not what Florence was saying.
No, Your Honor, I apologize if that's what I've articulated, but that's not what we're trying to assert.
It might be helpful to move forward in the sense that you have accepted, for purposes of this case, that the jail had reasonable suspicion to conduct the body scan.
Correct, yes.
And you are accepting that for purposes of the argument?
Absolutely. Yes, and our position is that the continuation of the search after Miss Harrow identified that she was wearing a bodysuit, which defendant Bradley knew at the time, which she conceded in her deposition, that bodysuits snap in between the legs. At that point.
Why at that point, I mean, I've seen the scan, why at that point would she have to conclude that these were the snaps?
And
I mean, not only for, for your client's safety.
Of course, and Your Honor, we do. So there are three separate lines that we would assert would not have violated Ms. Harrow's rights. First, we believe that it would have been reasonable for defendant Bradley to have stopped the search at the moment that Ms. Harrow informed her.
Sometimes people lie to the police.
Of course, and so.
So why would the police? Oh, it must be the bodysuit.
So the second point would be the point at which Ms. Harrow unsnapped the bodysuit. At that point, defendant Bradley would have known, would have heard the snaps. However, the very last point would be.
You're equating what the question to drill down on the point is. You've accepted that the officers had reasonable suspicion to search for contraband.
Correct.
What is equating the bodysuit with that of contraband? Because your argument is that reasonable suspicion was dispelled.
Mm-hmm. Right. So Sergeant Watkins and defendant Bradley both knew at the time of the search that the only grounds for the search, the reasonable suspicion, was a 1/4 inch circular dark anomaly that was identified on the body scan. That is consistent with the snap.
But it's also consistent with other things. That's the problem.
Correct, Your Honor. However, the snap. That's correct. Then how is reasonable suspicion dispelled?
Because where the question that a reasonable officer would have answered would have been if the anomaly is not these metal snaps, which it was known that the body scan showed, where are these snaps depicted on the scan? And I know that my friend on the other side argues that there could be something hidden behind the snaps. However, that's simply inconsistent with the facts here. There were 12 arrests.
It's reasonable suspicion, and the standard is objective.
Yes, Your Honor, but a reasonable officer armed with the facts that Ms. Bradley had in this circumstance, and those facts are that she knew the justification was the sole 1/4 inch anomaly from the body scan in the groin area. She knew that bodysuits snapped in the groin area, and once she was holding the bodysuit in her hands, could see that the snaps were on the bodysuit. At that point, a reasonable officer armed with those facts would have stopped the search. I see that my time is about to expire, and I would like to request the remainder of my time be held for rebuttal.
Certainly, counsel.
Thank you.
Ms. Rose.
May it please the court. I think the court hit on this already, but it is our position that it is not unconstitutional to have continued the search for which we had reasonable suspicion to conduct in the first place. And that's because of two things. In the evidence we have, the anomaly on the body scan did not look, even after we knew that there were snaps in the bodysuit, it did not look like a circular metal snap. And that's, now we know why. It's because they were all bunched together. But at that point, we did not know what the deal was. And the officer testified that it looked like it could be a pill in a baggie, which is what they were looking for. That was what the reasonable suspicion was. They were also trained, and this is under the collective knowledge doctrine, but they were also trained in this jail that a lot of times detainees are clever. And so they will hide things behind objects that they know will show up. And hoping that the officer will think, oh, that makes sense, I know what that is, and they won't investigate further. Here, there's no case law that says, at least I have found none, that says once you, because there were not two searches here. We're talking about one strip search.
And I guess the question on this reasonable suspicion, once the bodysuit is found, was there a constitutional obligation for that officer to require Ms. Horace to go back through the body scan machine?
We don't believe there was. We believe there was reasonable suspicion at the get-go. And the cases always talk about the initial.
Was it dispelled?
No, the language that I like in the cases, the only cases that I've seen that talks about this dispelled, and when they're not talking about different searches, they're not talking about doing a Terry stop and the officer's going further and then say, well, I didn't find any weapons, but now I'm going to pat you down for something completely different, for drugs or what have you, and that's a different type of search. Cases that are just talking about dispelling, what I've seen is they use that language, which I love, I don't know who had it, but once officers assure themselves that there's no skullduggery is afoot, they must stop the search. And in this case...
Where does that come from?
I'm sorry, Your Honor, I've got it marked here. I'd have to tell you. It's from a lot of the cases that we cited, though.
One thing that puzzled me about your brief is that you seem to accept the plaintiff's premise that reasonable suspicion is essential and has to be reassessed as the search continues. I don't see how that premise is consistent with Florence. So I looked in your brief to see what you said about Florence, and the answer is you don't even cite it.
Yeah.
The district court relied on Florence, right? The plaintiff's brief discusses Florence.
Yes.
It's the controlling Supreme Court precedent, and you don't even mention it. It wasn't. It left me incredulous. So are you conceding Florence away? Are you conceding away the benefit of the controlling Supreme Court decision?
We are not, Your Honor. That is an oversight on
How
our
else
end.
do I understand your failure even to cite it?
Your Honor, I don't have a good answer for that. I didn't write the briefs in this, and I know that's not a good answer for you. But we are not conceding away Florence. This was not a blanket strip search, and we believe that we would have had the right to do that had we had a policy. But as this court already noted, we were trying not to have strip searches. And I do not believe there's any case law, at least I've not seen any case law in preparing for this argument that says the reasonable suspicion has to be constantly
Florence
looked
holds
at.
that you don't need reasonable suspicion.
Yeah.
That's why I'm thinking that you're conceding that reasonable suspicion is necessary. That's all you're discussing. You're discussing something that Florence holds as a matter of constitutional law is not relevant. And it leaves me just totally perplexed.
The impression I had from Florence is that if the jail had a blanket policy, then it would not need the reasonable suspicion. But if you're looking at individual people.
The Constitution does not require reasonable suspicion.
That is correct.
Local jails or federal jails can require more than the Constitution requires. But failing to carry out your own policy is not a violation of the Constitution.
That is correct.
It's perfectly straightforward.
And I apologize, Justice Easterbrook, I think that's exactly where the mishap occurred, is in that distinction with our own
I brought up
policy.
Virginia against Moore, where that was the core hold.
Yes, this court is correct. But all the cases that are relied upon in terms of this being exceeding the scope of the search, once we knew that there were metal snaps to this bodysuit, are all in the context of officers going outside of, they have permission to do one search, and they go outside of it and do something else. And we just don't believe those are relevant here. So we would ask this court to we believe that this was constitutional. There is no 1983 viable claim here. Going further, just because we've not mentioned today about qualified immunity, if this court were to find otherwise and find that there was a constitutional violation, which the district court did not, rightfully so, and therefore the district court didn't consider the qualified immunity, but we would argue that if the court goes farther, Officer Bradley has qualified immunity because there was certainly no established case law that said, or established premise that says at every step you have to reassess just because a person tells you, hey, I've got metal snaps, or even if you see them, especially like in this case, one of the things we keep hearing is, the metal snaps are there, they would be obvious on the scan, you should have known that they were there. But in reality, there were two sets of metal snaps, and the scan only shows one anomaly. So that right there shows that, again, now we know why. It's because it was all bunched together. But at the time of the search was being conducted, we did not know that, and our officer believed it could be appeal. It could be contraband. And so we believe that there was, even under the qualified immunity doctrine, when you talk about, one thing that has to be shown is that here there is no analogous case. They concede that point, and there's no direct case law that's clearly established that would have said we had to do that. And then lastly, under the Monell claim, we would argue, this is the Sheriff's Department, they were entitled to summary judgment because they did not establish that there was a policy, practice, or custom that caused a constitutional violation. And here, there's certainly no widespread custom or practice. And the key issue under this factor would be whether it was a moving force behind her alleged constitutional violation. Here, the moving force was the body scan and the anomaly that appeared on that body scan that was not consistent just by looking at it with a metal snap, even when she learned there was metal snaps. And so we would ask this court to affirm the district court. If there's no other questions, I thank you for your time.
Thank you, Ms. Rowe. Ms. Bradley, I'll round you up to a whole minute.
Oh my goodness, thank you so much, Your Honor. To begin, the skullduggery quote was this court's decision in Lopez versus City of Chicago. And that full quote is, a person stopped on reasonable suspicion must be released as soon as the officers have assured themselves that no skullduggery is afoot. Now that follows Terry and its progeny that stand.
We have to engage with U.S. versus Freeman. It's a case that comes about 3 months after the Supreme Court's case in Florence, I'm sorry. And in U.S. versus Freeman, the Seventh Circuit, jail officials must have reasonable suspicion at the initiation.
Correct, Your Honor. However, the body of reasonability Fourth Amendment case law requires that a continual assessment of reasonable suspicion. Florida versus Royer is a fantastic example of that from the United States Supreme Court, and we would assert that that would be the case here. I see that I'm out of time. Thank you, Your Honors.
Thank you, counsel. The case is taken under advisement. Our final case for argument today is Flynn against Indianapolis. Mr. Land.
Thank you, Your Honor. Good morning, and may it please the court. My name is Matthew Land. I represent the appellant, Gail Flynn, on behalf of the estate of her deceased husband. We are here today as a result of the consequences of a police chase that resulted in the death of Miss Flynn's husband, who was not involved in the chase but was a bystander in an intersection. We'd like to talk about this circuit's Flores case and concept of res gestae, of time.
And I think we are here under unfortunate circumstances in regards to the aspect, the underlying of this case.
Yes, Your Honor.
I think that where I am concerned, starting with Flores, is when we have answered this question, Elizabeth versus Henderson, that Flores comes off the shelf only in non-emergency situations.
Yes, Your Honor.
And so I guess that's, before I can get to Flores, I have to grapple with Lisby, where we have kind of put bookends on where Flores goes.
Yes, Your Honor. So in that case, I won't need to address the Flores part about it having a different standard. We'll just skip straight to the application of Flores on whether this was an emergent or non-emergent situation.
Because if it's emergency, why would we not pull down Lewis to assess this case?
I concede that you would have to, Your Honor. I concede that you would have to. So this does narrow things nicely.
But we do here.
Yeah, yes, Your Honor. I appreciate that. So question becomes, if there is an emergency at time T, at the initial stop, or at the initial moment, does that emergency last forever? Can an emergency dissipate and allow time for deliberation? Can an emergency, change from what it is at the moment to a non-emergent situation? Because if we do look at Lewis and the progeny, including Flores, the underlying motivation, the underlying principle of why we're concerned about what is an emergency and what is a non-emergency, we're concerned about time for deliberation, right? Just as the underlying facts for my client are unfortunate in this situation, the job of the police to protect us is not an easy one.
Give you a case with time for deliberation and see what you think.
Yes.
An armed bank robber enters a bank.
Yes, Your Honor.
Threatens to kill the teller unless the teller gives them the money. Teller pulls the alarm, and the police surround the bank. They broadcast with a megaphone, "We have you surrounded. Come out with your hands up." And at that point, the armed robber shoots the teller, who dies.
Yes,
Are the police liable on the ground that, there's no emergency, they could always just let the bank robber escape?
Your Honor, I would say that in that situation, the bank robber has shown a tendency to be explicitly harmful to those around him.
Indeed, on your view, that sounds like you're saying, and therefore the police must let the bank robber go free.
No, Your Honor.
Because the bank robber may carry out his threat.
No, Your Honor.
In the actual case, there is an ongoing crime, right?
Correct.
The criminal is fleeing from the police. The crime is ongoing at every minute, and the police are trying to halt the crime. And they decide they will try to halt the crime rather than let the criminal escape.
Correct.
I don't know why these situations are different. In each one, the police may have had 5 minutes before the criminal kills an innocent third party.
Yes, sir.
Why are they constitutionally different?
Your Honor, I would go back to where I was going with the danger of the particular suspect in your hypothetical. I would say if you were to let this armed bank robber escape, you're weighing risks at that point. When you do have the time to deliberate, I think that's when we start talking about weighing risks.
In my case, the police had the time to deliberate.
Correct, Your Honor, and I think...
Or the Sinaloa cartel threatens to blow up an airplane unless the Attorney General lets El Chapo out of federal prison.
Yes.
The Attorney General says no, the cartel blows up an airplane. As the Attorney General violated the Constitution of the United States. He had plenty of time to think about this.
Correct, Your Honor, and I would say that at that time, he had the time to think about it and weigh the risk, and then he made the right decision. Just as they made the right decision.
Whether it violates the Constitution has nothing to do with whether you agree with the Attorney General's decision, right? The question in all of these cases is, must the police let a dangerous criminal escape rather than allow the danger to continue, right? The fleeing felon is a dangerous criminal. The bank robber is a dangerous criminal. The Sinaloa cartel is a bunch of dangerous criminals.
Yes, Your Honor, they are.
And if the fleeing felon has to be allowed to be let go, I don't understand why the bank robber doesn't have to be let go. They're all dangerous.
I agree. In our case, we did not know that there was a fleeing felon. That was not a fact within the
The fact that you are
consideration.
fleeing from the police makes you a felon. It's a violation of felony law in every state in the union.
Okay, fleeing, the fleeing felon, I apologize, the felony of fleeing rather than the fleeing previous felon. So I apologize for getting confused with the gerundive. The point here is not that they have to let all dangerous criminals go. I disagree with the fundamental question being the fundamental question, Your Honor. I think.
No, you say that as long as it's no longer an emergency, as long as you have time to contemplate, then you gotta let them go.
Mm-hmm.
That's why I'm giving you cases where the Attorney General had plenty of time to contemplate.
And respectfully, Your Honor, I wholly disagree that that is what we're saying.
It certainly comes across as what you're saying.
Well,
the only thing the police could have done here that in your view is consistent with the Constitution is allow this man to escape.
As applied to this case?
Yeah.
That
to allow a dangerous fleeing felon to escape.
I'm not taking a position, Your Honor, at all on whether or not they should have or should not have let him go. I am taking a position on whether or not the deliberate indifference standard.
You required them to let him go. That's what your case is about.
All right. Your Honor, we're saying that a reasonable juror could decide that. I'm not saying that.
The reasonable juror does not set the meaning of the Constitution.
Agreed, Your Honor, but what standard applies?
The Supreme Court has announced a constitutional standard, which is whether the police are trying to harm someone or instead are just trying to stop a fleeing felon.
So, Your Honor, this gets to the distinction between the intent to harm standard and the deliberate.
But you can't get to the standard until you know, are we in an emergency situation or not? Are we engaging in the moment of trying, and because that's where the Supreme Court said that's the dividing line of deliberate indifference or intent to harm, is what are the circumstances, the context.
Correct.
That's why Judge Easterbrook is needing you to answer the question of, in the case of chasing a fleeing felon.
In the case of chasing a fleeing felon, the circumstances can exist such that the emergency dissipates to the point that they should be judged under the deliberate indifference standard and not the intent to harm.
Then you have to answer my question by saying that the police must allow the bank robber to escape. The situations are identical. Some fleeing felons will run down and injure innocent parties. Some armed bank robbers will kill the tellers. Many won't. You can't tell in advance which is which. And the burden of your argument is that as long as the police have time to think, the only answer they can give is let him escape.
Your Honor, respectively, there's a false dichotomy in there in that letting them escape is not the only option. Pulling back, calling for, air cover to follow the car, putting out any other means of doing this. It doesn't necessarily mean that they have to let them escape. And also, it doesn't mean that they have to even stop the chase. It just means that if they have had time to deliberate, if they do make a mistake, if something is unfortunate does happen, it is no longer the intent to harm standard. It is the deliberate indifference standard. And that is the argument that we are making.
So is it your suggestion that it is the time to deliberate that changes it from an emergency situation to a non-emergency situation?
Yes, Your Honor.
Even though the criminal conduct is unchanged?
Yes, Your Honor. If we're going to...
still fleeing?
The felon is still fleeing.
The robber is still in the bank.
The robber is still in the bank. The robber is still in the bank, although I think that those are a bit of an apples and oranges situation between the robber and the bank and this fleeing suspect. But when you have time... If
I have time to think about it.
Yes, Your Honor.
As law enforcement, then I have to go home.
No, Your Honor. If you have time to think about it, you are judged under a deliberate indifference standard and not the intent to harm standard. You just have a higher duty to be careful.
I just don't get this. Deliberate indifference is a form of intent.
Correct.
To say you were deliberately indifferent to a particular harm is to say you had an intent to cause that harm. There isn't any difference. The holding of Lewis is that you need intent to harm, regardless of how that intent is formed. And you've conceded, I take it, that you're not, that you, these police officers did not intend to harm anyone.
Absolutely.
Yeah, well, then
If
then we all get to go home.
I see that I'm out of time, but if I can answer your.
Oh, as long as we're asking questions, you can keep giving answers.
Yes, Your Honor. What you're saying, you started with, is that intent to harm and deliberate indifference are the same thing, and they are. I can
And that
point
is
to
the holding of the Supreme Court in Farmer against Brennan.
You are correct.
Oh, good.
I read those lines, and honestly, they make very little sense to me. The Flores
It made
case
sense to the Supreme Court, and that's all we care about.
didn't seem to be what the
Constitution calls us
Flores.
an inferior court.
It didn't seem to be what the Flores case stands for, though, Your Honor. It does seem that the Flores case.
Flores case did not come into play.
It was never an emergency in Flores.
That's the point.
There was never an emergency in Flores. It wasn't that one began and stopped. It was you have a police officer who gratuitously puts people at risk, for no reason.
Agreed.
Now, one can argue about whether Flores is compatible with Sacramento against Lewis. But there is no doubt, you concede that there was an emergency situation. We have a fleeing felon, right? And the police have to decide what to do. The decision, right, they have to decide. Puts us in the world of this.
Fair enough, Your Honor.
Okay? All right, thank you, Mr. Land. Mr. Will. There are, of course, no bank robberies in Indianapolis, so I would never raise such a hypothetical with the lawyer for the city.
Good afternoon. My name is Alex Will, and me with Mr. Raymond, we represent the city of Indianapolis and the individual officers. May it please the court, the district court in this case properly applied the 14th Amendment's intent to harm standard at summary judgment, where it's faced with a high-speed police pursuit of a suspect who was driving a stolen vehicle, who suddenly backed that vehicle at a high rate of speed into Officer Butler's patrol car and almost struck Officer Butler and Officer Omari Stringer and then fled them on a high-speed pursuit. In its decision in the County of Sacramento versus Lewis, the Supreme Court unambiguously stated that high-speed chases with no intent to harm suspects physically or worsen their legal plight do not give rise to liability under the 14th Amendment. That is the standard that must be applied here. And when applied, there is no evidence of intent to harm either the suspect, Mr. Flynn, or anyone else. As a result, summary judgment should be affirmed in all respects. The primary issue raised by Ms. Flynn in this case is whether the district court should have applied the intent to harm standard or the standard enunciated under Flores. As the court has adequately picked up, the Supreme Court has addressed this and it unambiguously said in high-speed pursuit cases that an officer cannot violate the 14th Amendment without showing an intent to harm. And that was a categorical approach. It said high-speed chases, high-speed pursuits. This is exactly what we have here. The evidence is undisputed that there was a high-speed pursuit, that the officers were chasing a suspect who was in possession of a stolen vehicle, who had attempted to strike officers and had struck a patrol car and fled. Moreover, as the court has also noted, Flores is not applicable. Flores did not result from a police pursuit. Flores was a non-emergent situation involving an already affected traffic stop in which several officers were already on scene. There was no indication of an emergency. Ms. Flynn's counsel has talked at length about time for deliberation. And I think it merits pointing out that time for deliberation, as enunciated in Lewis, is not intended to be a period of time. It recognizes deliberation is an unhurried judgment as opposed to an instantaneous judgment. And I think as this court picked up, in these tense, high-pressure situations, there's a difference between decision-making and deliberation as considered by the Lewis court in this standard. In fact, there's a footnote that said it's not even the deliberation that occurs in homicide case law where we talk about a moment or an instant of time. They've cited in their brief that Lieutenant Ryder made some decision-making, and he admitted to making some decision-making. Again, it bears noting the decision-making that Lieutenant Ryder was making as a supervisor was not unhurried. It was instantaneous in a situation while his officers were chasing a fleeing suspect. There is a difference between that type of decision-making made in haste, under pressure, and without second chances, and what was in a time for true deliberation, as the Supreme Court considered. 5.5 minutes is not a significant period of time to deliberate. There are thousands of decisions being made in this period. The officers are driving their vehicles, monitoring the vehicle in front of them, monitoring speeds, clearing intersections, and communicating. They are working as a team to carry out. There's not a moment to deliberate, as the Lewis Court considered it. In fact, Officer Stringer, the lead officer who was following the vehicle, said this. He was expressly asked at what point in time he talked with other officers and made a decision about whether they should pursue, and he said, "I never spoke with them. We were engaged in the pursuit. There was never a time for us to say, hey, let's stop real quick and talk about what we have here. We were in the moment." That is what we have here. Based on this and applying this standard, you can see, and I think counsel has conceded here today, there was no intent to harm. The officers made a decision. They made a decision to pursue, and they considered in the heat of the moment to consider that pursuit. Unfortunately, the results are tragic, but that does not mean it was a substantive due process violation. And again, that complies with Lewis, which expressed a concern of expanding due process case law and expanding these substantive due process rights. I think that's what counsel is asked to do here, and I think the court should rely instead on Lewis and Steen and affirm the district court in all respects. Unless there's any questions, thank you for your time.
I see none. Thank you very much, counsel. The case is taken under advisement, and the court will be in recess.